Get started. Welcome to our first webinar in the healthcare industry lunch and learn series. Today we're going to focus on venture capital, do's and don'ts for physician entrepreneurs. I went ahead and put a picture of a seedling on the slide, not only because of the fact that we're talking about seed capital and seed funding to some extent, but I think this topic has a similar energy to it, growth and progress and new beginnings. I really like working in this space because it's about building something new that matters. So Kevin and I are just lawyers. Well, Kevin is actually an entrepreneur as well. But this next few minutes, we're going to talk about kind of the do's and don'ts from a legal perspective. So as I mentioned, my partner Kevin Saunders and I are going to lead today's discussion, and we'll say just a few words about our own practices so you know a bit about our background. I'm Kate Hickner. I'm a healthcare transactional attorney with a national health law practice. I'm licensed in New York, Ohio, and Michigan, but I work with healthcare businesses across the country. My practice includes everything from compliance to employment agreements to mergers and acquisitions, forming startups, and leading capital raises. And now I'll let Kevin say a few words about his practice. Kevin?
Good afternoon, everyone. Thanks for joining us. Thanks, Kate, for inviting me to participate with her here. Hopefully I can add a little bit of value. In a similar vein to Kate, I am a transactional attorney in our Cleveland office, though unlike her, I am not nearly as expert or specialized in any specific industry or niche as she is with healthcare. More of a generalist. I do M&A transactions, real estate development, and securities offerings related to both. So yeah, hopefully be able to add some value to this conversation, mostly on the venture capital and the early stage startup formation and capital raising.
Okay, thanks, Kevin. And while we're waiting for the slide to turn here, do you want to share just a few words about our BMD Ventures group?
Yeah, sure. So though BMD has had the expertise, floating around in offices and amongst various attorneys, more recently, since Kate joined us up in the Cleveland office and we've worked together on a few deals, we decided in conjunction with our Akron office and office managing partner down there, Lee Walco, kind of formalize this into a group, a BMD Ventures group. And this kind of goes in conjunction with a lot of the early stage ecosystem buzz and momentum that's been building in Northeastern Ohio and the Midwest more generally recently. Seen a lot of activity, migrate inwards from the coasts, and a number of big unicorn valuations and 9-figure offering amounts amongst Cincinnati, Columbus, and Cleveland companies, as well as recently announced the innovation districts in all three of those cities as well, in conjunction with Jobs Ohio and funding at the state level. So we formed a venture capital team with the idea of helping early stage, so we're talking seed stage, Series A stage companies get off the ground and locate capital to kind of take their idea to from the idea stage to commercialization, and helping them with all the various obstacles and milestones that they need to hit along the way there.
Okay, thank you. And just, following up on Kevin's words, I just want to mention that our firm has a very strong empowerment and opportunity committee. And we've developed a special emphasis on women-owned and minority-owned businesses. And there'll be more information coming out within the next few months on that topic, but it's something that Kevin and I are really excited about. I'm going to go ahead and jump back a few slides and just kind of touch upon the objectives for this discussion. Obviously, we're going to cover we're going to discuss options for structuring new businesses and investments. We're going to outline key investment documents and related terms and considerations. And then this presentation Lunch and Learn is focused on physician entrepreneurs and investors. And so we're going to cover a few common healthcare regulatory pitfalls as well. The goal is really for you to walk away from this Lunch and Learn with a few pieces of guidance that you didn't have before that you may be able to apply to your business. And if you have more follow-up questions that are specific in nature, feel free to reach out to Kevin or I after this. We're always happy to brainstorm and help you issue spot. And there may be some time at the end of our slideshow as well to kind of talk about some topics in further depth. Okay, so I went ahead and I put a quote up here. The myth is that venture capitalists invest in good people and good ideas, and the reality is that they really invest in good industries. And so today, obviously, we're talking about healthcare. The healthcare industry is big business. The quote up here says, at the macro level, the healthcare industry continues to be one of the fastest growing and most consistent segments of the US economy. It's good for investors. By 2022, it's anticipated to account for 19.9% of the GDP at $5 trillion. And I put a few citations of relevant articles kind of elaborating upon that. But healthcare is, for good or for bad, big business, certainly. The healthcare industry is doing well in some areas, but that said, not in others. And so it's important to understand this. Operating margins for hospitals that's decreasing. Hospitals are incurring a tremendous amount of uncompensated care because of our healthcare payment system in this country. For investors and entrepreneurs, the margins are much more favorable for pharmaceutical companies, health information technology companies, and healthcare product companies. I know in our practice, we do quite a bit of work on the telemedicine space, telehealth, with software companies. We have a lot of clients that are focused on improving access to care and delivering care in a more efficient manner. I would say that the vast majority of the clients that I work with have a heavy emphasis on intellectual property, a strong focus in that area. And I work with my partner, Paul Phelan, to ensure that the trademarks and the brand of each business is in order. We're actually enforcing a few trademarks for a handful of clients against infringers. It's pretty bold, some of their activities out there, and the importance of protecting the brand is more and more important. So we have a strong team to support these companies. That being said, in the past few years, I've worked with several large syndications and sales of healthcare providers. In my own practice, those deals have been in the primary care orthopedics space, and then also with dental service organizations. Based upon the market data that's out there, it looks like what I'm seeing is pretty typical. Again, I mentioned primary care and orthopedics. We're seeing a lot of activity in that space. Also, the market data shows that women's health, urology, ophthalmology, gastroenterology, podiatry, as well as others, are very common to see private equity activity. And so, as I mentioned, the presentation is going to highlight a few do's and don'ts. Again, we're here to answer any follow-up questions that you have. The first do that I have is consult your trusted advisors. Don't proceed alone. And if you're an entrepreneur starting a new business or thinking about investing in an existing business, consult your advisors at the outset. You need to think about the corporate structure and the documents. There are a lot of options here, and pros and cons, and the documents do matter. You need to think about the key legal agreements so that your investment's protected. And again, need to think about intellectual property rights. And Kevin's going to talk about the structural options a bit further.
Yeah, so I know we have a lot of detail on this page, and this is mostly an overview and primer. So without getting too far into the weeds of all of the various structures and investment instruments, I guess suffice to say there are a lot of different ways to slice the cake here. So in the theme of the do's and don'ts of venture capital, we would encourage you though always wanting to be, sensitive of fees and rates in the early stages of a business, we would encourage you to consult with legal counsel early on structuring considerations, both from an organizational and entity perspective, as well as an investment instrument perspective, and trying to put together, a business plan and a roadmap that goes along with your business plan, thinking forward of what sort of capital resources will be needed over the course of the timeline of the business, and working backwards to kind of structure the various steps accordingly of your first raise, to leave yourself room on your second and third to add more, and accounting for dilution. And there's just, a lot of different variables that go into this. So if you plan smart on the front end, it can really help both tell your story and eliminate a lot of common pitfalls and headaches long term. So counterintuitively, you can actually, save yourself money in the long term by spending a little bit more time and resources up front planning everything out.
And Kevin, can you, I know one of the common issues that we see when people move forward without consulting legal counsel is they may organize a new company that eventually will take on private or venture capital. They may organize it in a state other than Delaware, or as a LLC instead of a C Corp. Can you talk about those considerations a little bit further?
Yeah, certainly. That's a great point. This is probably the most common one we see. And it's not to say that there's only one way of going about it, but typically, if you get to your Series A or Series B, or, if you're very successful, Series C and onward, you're going to be looking for more sophisticated capital from actual venture capital funds and sophisticated high net worth investors. And these folks, once you move outside of your friends and family network, the typical structure for an entity raising venture capital funds is to be a Delaware corporation. This is for historical reasons, for certainty of law. Delaware has long-standing corporate legal jurisprudence, so folks are comfortable with that one state rather than getting comfortable with the individual law of 50 different states. So early on, generally, for an Ohio startup company, they'll usually form themselves as Ohio LLC. And that's not necessarily the end of the world, for a seed raise, if you're looking for mostly friends and family money, or you have close relationships with your investors, perhaps you can get through a seed round with an Ohio LLC. But ultimately, if you get to that next step and you're going out for a broader base of investors and starting to get into that next rung in terms of sophistication, there's probably going to need to be a conversion into a Delaware C Corp. So to Kate's point about planning this early on, you can either start there with the Delaware C Corp, or just form a streamlined entity with very abbreviated, simple documents on the first step, and wait to spend your money and resources on building out more complex, sophisticated documentations until you convert, so you're not spending the money to do it twice.
Mm-hmm. And I know some of the safes that you and I have seen recently require that eventually that the entities be converted to a C Corp, even if they're not now.
Yeah, often that's a negotiated term in a term sheet or the investment documents in the first round, is that any subsequent rounds will be on, a standard set of venture capital docs that are accepted by everyone. And for those venture capital docs, they're geared towards or set up for a Delaware corporation. So implicit in that is that there would be a conversion before that next offering.
And I was just wondering if you could touch upon kind of the pros and cons of a safe versus a direct equity investment for a physician investor versus perhaps the founder of the company. I know, I think sometimes that's missed by investors, and also for founders that maybe don't think to kind of go the route of a safe. So I just thought that might be helpful for the attendees to hear.
Yeah, no, that's a great point. Well, safes, for all those who don't know, I'm sure most of you are aware, is the simple agreement for future equity. And basically the reason that it came into existence was to reduce cost and administrative burden of documentation for these extremely lengthy convertible notes early on. Convertible notes are great for investors early on because it provides you with a superior lien position as a creditor rather than an equity holder should things go sideways. But because they are a hybrid instrument that has both debt and equity features, the convertible note, typically the instrument is extremely long, extremely complex, and that can add a bunch of extra cost and time on the front end when these organizations are trying to move fast and devote as much of their dry powder as possible into the actual business model. So a safe can be a more streamlined option, but the trade-off or exchange there is all of the terms aren't hammered out and set in stone. It's basically saying, once we get to our next capital raise, then we'll set these in stone and have a more extensive investment instrument. So that can be great from the founder's point of view, but from an investor's point of view, you have to be careful there because a lot of time, well, I wouldn't say a lot of times, but we have seen, and I think we've seen it increasingly lately as we've moved into a more founder-friendly environment with so much capital flying around. But sometimes in the safe they won't set a cap, so you'll get converted in the next round or get your investment converted into a right for future equity at a valuation that's much higher, meaning your investment will get you less equity proportionately than it would have at the time that you invested. So basically you're not getting the adjusted risk premium for your investing earlier on in the timeline and life cycle of the company when the risk of failure is much higher. And that's obviously very detrimental to the return on investment and the attractiveness of the investment opportunity from an investor's point of view.
Okay. No, thanks for that explanation. Is it okay if I go to the next slide?
Of course.
Okay.
Okay, so other considerations to think about and structure for early on are the securities law. I think we have a bit more of a sophisticated group on this call, so I'm sure most, if not all of you, are already aware. But one of the things we run into with early stage founders is a lack of clarity or understanding around what exactly is a security. And there's a common misperception that if you just have one or two or three angels or high net worth individuals that want to invest, or maybe they're just giving a loan and it's a note, well, then that's not a securities offering. And it absolutely is in most cases, unless it's a registered financial institution or a couple other handful of exceptions. In most cases in these early stages, if you have some individuals that are completely passive and hands off and are giving money to a founder or group of founders, an expectation that their skills or network or special expertise in this industry is going to lead to a return on investment for the LPs, that's a security any way you cut it. And that leads to a host of securities law considerations, and you need to make sure that you fit into them. And it's fairly easy as long as you're working with an attorney to fit within those exemptions, as long as you follow certain guidelines and limit your solicitation to certain groups of investors, depending on which exemption you ultimately choose. But depending on whether you're seeking solely accredited investors or if you're going to allow a sliver of non-accredited, if you're doing general solicitation versus non-general solicitation, then these listed documents that we have here on the slide, you'll either need to do all of them or a subset of them. And you work with legal counsel, help you make sure you're disclosing all of the adequate risk, getting all the reps and warranties from investors you need in your subscription agreements, and that ensures that down the line, should anything go sideways or any investors become disgruntled, they don't have the ability to go to the SEC or your state securities enforcement agency and cry foul. Which, if they were to do and have that ability, not only would all your investors have a right of rescission, but you may be prevented from participating either as an investor or a issuer in future securities offerings, which obviously would be very bad. So it's important stuff.
It's so Kevin, if there's a physician who's starting a new company and maybe doing the first or second capital raise, doesn't have a lot of resources yet in this new startup, and let's say all of the potential investors are accredited investors, what's your general advice on the offering documents that they absolutely need versus documents that they could move forward with to mitigate risk?
One question, Kate, are all of your accredited investors personally known to the issuer, or is there general solicitation involved? Like, are they listing it on a angel list, or I know there's some Angel MD, something like that portal.
I guess I'm thinking about like a typical 506 Reg D offering where they would all be known.
Okay.
The founder.
Okay, so then, well, by a strict reading of securities law, you may not need a private placement memorandum if the business isn't already in existence. If it's already in existence and has historical financials, you would need to disclose the last 2 years of historical financials, even if it's just tax returns. You put that in a PPM, as well as the total offering amount, the material terms of the investment instrument, the issuers or the founding sponsor group, and things like that. And then you would need a subscription agreement, or what you're calling a disclosure document in here, that has all of your risk factor disclosures. So basically it says in bold letters, do not invest in this offering. This is very risky. If you can't afford to lose all of your money, don't invest. And then we'll have some healthcare specific disclosures related to the risk factors for the healthcare industry, regulations and HIPAA and operating risks and things of that nature, as well as it'll have a series of representations and warranties that the investor will make, that self-certifying that they're an accredited investor and that they've read all the disclosure documents and they've had an opportunity to pose any questions, the founders, and et cetera, et cetera. And that would probably be it if you wanted to streamline it as much as possible.
Yeah, I agree with that. And we'll talk a little bit more about it in a few minutes, but raising capital in the healthcare space or investing in the industry, there really are unique and sometimes substantial risks and that need to be considered for sure. And so if we're representing the company, we always make sure to highlight those issues in the private placement memorandums. Another question that I often get from founders will be, hey, we're doing a capital raise. Should we ask everyone to sign an NDA at the outset? And my experience is that potential investors are not willing to sign an NDA, to receive and review the slide deck and even usually the disclosure document and private placement memorandum. But when there's further diligence that's conducted with a data room, et cetera, that's usually when the NDA comes into play. Is that your experience as well, Kevin?
Yeah,
okay.
Absolutely.
I get that question a lot because I know founders are obviously very protective of the company information. I don't know, do you want to touch upon diligence?
This is from the investor side?
Yeah.
Yeah, diligence is a very interesting topic, especially as we get later and later into the bull cycle. And as I mentioned, founder friendly, and a lot of capital competing amongst each other. You see a wide spectrum and varying approaches to due diligence. Depending on the size of your investment, it really kind of limits how much due diligence you can afford to do if you're hiring it out to legal or financial counsel. or really how much time or energy you're going to be willing to spend on it yourself if you're making a $50,000 investment versus $500,000. A lot of times we'll see smaller LP investors wait to see a lead investor, a venture capital shop, or a lead physician, surgeon, or a strategic healthcare organization, and kind of piggyback on their due diligence. But at the end of the day, somebody needs to be doing the due diligence to make sure that the reps and information contained in the disclosure documents, the PPM, the financials are accurate and correct. Because as we were just talking about on the previous slide, ultimately as an investor, whether you know it or not, you're making representations and warranties that says you've read everything, you understand the risk, you've had the opportunity to consult with professionals, legal, tax, financial, accounting advisors to analyze the business. And the risk factors basically say this is extremely risky, you could lose all of your money. So you can't come back at the end of the day just because the investment didn't work out and say, oh, this didn't work out, you deceived us. It is really kind of buyer beware, and the burden in these private placements is on the investor as a sophisticated individual to do their research and determine whether the investment merits the risk that you're taking. So there are a number of portals, publicly available databases, and increasingly so in today's day and age, where you can search individuals to see if any of the issuers has previous securities law violations, see if they have or are prohibited from raising capital, to see if they filed their Form Ds, to make sure that they're checking all the appropriate boxes for the current capital raise. Looking into whether they have in the PPM, or just asking them directly, a cyber insurance policy or cyber security protocols in place, specific medical licenses, CONs, whatever the case may be. Just check the boxes and make sure what they're saying is actually true before you write a big check.
Yeah, I agree with that. And I guess I would, from a health law perspective, just emphasize kind of the last two bullets on the slide up here, cyber and reputational. We're working with a few different clients right now who are responding to investigations related to HIPAA breaches. It happens much more frequently than you would think, and some of them are really significant. I have a client that one of the patients Googled their name and realized that test results for thousands of patients were placed online and visible via Google when the patient Googled her name. And the other issue would be, which obviously brings financial risk to the business that somebody's investing in. The other thing that I just emphasize is reputational, and there's kind of this do and don't highlighted here on the right-hand side. Do align with others who respect your medical license and the related risks. Healthcare is so incredibly regulated, and I had a client, I won't share a lot of detail, but I had a client a few years ago, one of the top physicians in his specialty decided to help out a family member and invest in a convenience store to help the family member's business. And the bottom line was that an employee of the convenience store traded food stamps for cash, which is a federal crime. And because this physician client that I had was an owner, he was put on the excluded provider list. So I worked with counsel that focused on SNAP issues, and we got him off the list. But if you can imagine a physician being suspended from his employment and not able to perform surgery for people that had been waiting for this person for months, all because an employee at a convenience store where he had a partial minority interest had committed a food stamp violation. And so, physicians are licensed individuals, and it's really important that physicians align only with those who really respect compliance, because very unexpected things can happen, and a physician doesn't have to have bad intent in order for their career to be destroyed. So it's easier to misstep than one would think. Similarly, medical device companies and other investments where there are marketers that go rogue and violate the anti-kickback laws or other laws that marketers often do, get off track in those areas. Physicians who are related to those companies can be significantly impacted. So I would just, not to be too risk adverse, but I'm a lawyer, so that's what we do. But it's really important to remember.
Yeah, and I guess just to hammer that point home, the quintessential example, contemporary, is Theranos, right? As this has all kind of come out on trial in the depositions and come into the public light, basically what it all came down to is two of the founders were blatantly lying in their investment prospectuses, and these investors who collectively put in over $100 million never checked. None of them, which is mind-blowing. And what I was saying at the beginning, I mean, you see a lot of different approaches, and when it comes down to it, you see a lot less due diligence from investors than you would think. But these very sophisticated venture capital funds, very sophisticated high net worth individuals, very sophisticated healthcare companies never called CVS or the Walgreens, whoever it was, to see if they actually have the partnership and to see if these machines actually were in these amount of stores, and they weren't. And simple due diligence would have uncovered all of it and saved them from losing hundreds of millions of dollars.
Yeah. All right, so I guess we'll move on just because of time constraints here. We'll talk a little bit about some key terms of the governing documents. In addition to conducting diligence, it's really important to understand what you're getting into if you're a physician investor. And having an 80% interest and having a 20% interest in a company may sound very different, but depending on the ways that the governing documents are written, they may be written in a manner that makes those two percentage interests actually pretty similar through reserved powers, veto authority, governance structure, buy-sell provisions. It never fun to hire a lawyer, but it's important to know the terms of the deal. And if you're a minority investor, it's important to ensure that the governing documents provide basic minority protections. Can you, as an investor, be forced to guarantee debt of the company? Is there a cap on the guarantees? Can you be forced to contribute additional capital? What happens if you don't, or if you simply can't? Are you diluted? Are you kicked out? Do you get your money back if you're kicked out? Is there a waterfall in terms of profit distributions? Is there a manager that's going to receive a carry? Is it market? Is it 20% or 90% of the profit? What is your percentage interest in your investment really get you? Kind of the devil's in the details along those lines. Buy-sell provisions, can you exit the company upon death, disability, if you retire, if you're a physician? Can you assign your interest to a trust? Can you sell your interest to a third party? Is there a right of first refusal? Can the majority sell without taking you along with them, or are there tag-along rights? And so there's lots of things to consider and to be aware of when you are presented with the governing documents, when you're looking at the subscription opportunity. Another thing you want to focus on are conflicts of interest and whether the documents limit the fiduciary duties of those in control. If you invest in an ambulatory surgical center, for example, can those in control set up a competing center across the street if they want to go that route? So understand what you're getting into. Similarly, it's really important to look at restrictive covenants in the governing documents. If you're starting a business, you'll want to protect your confidential information and goodwill, and that's reasonable and appropriate. But if you're investing in the business, you'll want to make sure that the investment doesn't preclude you from other important investments or even practicing medicine as you currently are. And in most states, restrictive covenants are enforceable if they're reasonable in terms of scope, duration, and geographic area. That's certainly the case in New York and Ohio and Michigan, where I'm licensed and practice frequently. But the company has to have a legitimate interest in enforcing the restriction. And just kind of on the slide, it listed a couple different types, or a few different types of restrictive covenants. The typical non-competition provision, also non-solicitation, very important for the owners and founders of the company, protecting their customers and referral sources, employees and contractors. And then obviously we often see confidentiality and non-disparagement provisions as well. We need to think about how the restrictive covenants in the documents generally will impact your relationships as a whole. Kind of what are your deal breakers when you're looking at the big picture of your career and your investment portfolio? What needs to be in the documents? What can't be in the documents? Are there promises that have been made and expectations that are part of the deal that should be documented so you can rely on them? A lot of physicians will be involved with new startups in several different capacities as a board member, officer, employee, advisor, clients. All of these get into healthcare regulatory issues, anti-kickback risk, self-referral laws, that could be a whole different presentation, but we need to kind of think through all of the relationships and not just look at one particular investment in an isolated fashion. We also need to think about how the investment would impact other relationships that a physician has, employment agreements, restrictive covenants, fiduciary duties. So I hear this phrase a lot, don't build the plane without flying it. And it kind of annoys me. It's said a lot of times on Zoom calls lately, but that's exactly what we're seeing, especially in the lab space. I work with several large labs on the East Coast, and one in particular started before COVID and realized that there's incredible financial opportunity associated in the lab industry right now because of COVID testing, and they really didn't feel like they had time to engage a lawyer or adopt a robust regulatory compliance program like they needed to do, and now it's a problem. And so I just can't overemphasize this enough. All healthcare industry businesses have to have an active and robust regulatory compliance program. The risk is the greatest for the licensed individuals and the licensed physicians, and they're sometimes subject to pressure from business development folks or others who don't have a license. And it's really important to protect physicians and make sure that they don't get into a situation like I mentioned before with my client that invested in a convenience store. He had no way to anticipate what would happen. So it's important to dot our I's and cross our T's. Every physician compensation arrangement, both indirect and direct, needs to be reviewed from a health law perspective. And the government documents need to be finalized and executed at the outset. That's just a basic corporate law principle to kind of protect your rights and expectations and investment. You need to get the deal in writing. There's lots of bad operating agreements out there, or agreements that are produced on LegalZoom that are just completely insufficient. And so it's worth a little bit of money to get it set up right at the front end. Many of you on the call have probably read Atul Gawande's Checklist Manifesto, which is a great book that talks about the importance of checklists to airline pilots and physicians to make sure that there aren't errors. And healthcare lawyers have their own checklists because health law is actually very complicated. There's lots and lots of issues to consider at the federal and state level, in addition to kind of the securities law and corporate law issues that Kevin was highlighting earlier. A lot more on my list than what's up here on the slide, but these are the issues that I come across most frequently for physician entrepreneurs and investors. Lots of gray areas and judgment calls in this space. So it's also important to have a lawyer that has a risk tolerance that's similar to yours, because reasonable minds can disagree, certainly. I'll just touch upon the federal anti-kickback law because it's something that I work with every single day, like literally every day when I'm structuring financial relationships and joint ventures and doing the deals, because it's very broad. It's a criminal law and it's intent-based, and it's in its simplest form. It says that we can't pay for payments, or I'm sorry, we can't pay for patients, but it's much broader. The law actually provides that nobody can provide anything of value for the generation of business that's payable by Medicare, Medicaid. or another federal payer. And so what that means is that any party in a position to generate business, if they receive less than fair market value for something, or I'm sorry, if they pay less than fair market value or receive more than fair market value, the government will deem that to be an impermissible kickback. So everything has to be fair market value in the healthcare space. Fair market value, it becomes not only a business term, but a legal term. And there's a special definition of fair market value in the federal regulations. It cannot have any like consideration of the ability to generate business. And it's really counterintuitive to capitalism. So it means that there are things that we can do in any other industry that we can't do in healthcare. And so in addition to dealing with this law every day, I get pushback every single day from clients saying, I don't understand, everyone's doing this. And, there might be people in the healthcare space that are paying up, above fair market value or charging less than fair market value, but that doesn't mean that it's permissible and defensible, and the risk is high. Because the law is so broad, there's a ton of guidance out there, advisory opinions. I actually worked with my colleague Kevin Kripe to request an advisory opinion for a medical device company recently to bless a joint venture that we were structuring. There are also several safe harbors, and if you don't have to fit into a safe harbor squarely in order to be defensible under the anti-kickback law, but if you do fit within a safe harbor, that it's protected. I will tell you, based upon my last advisory opinion request, that the government is extremely conservative, and so they may disagree that an arrangement fits within a safe harbor. And the government is definitely not always correct. Sometimes they get it wrong. And so it's important to not take on unnecessary legal risks. So again, medical device companies, labs, software companies, telehealth companies, so many that we work with need to be very cognizant when they're offering investment opportunities. There's a whole body of joint venture guidance that, among other factors, provides that physician investments need to be, the capital that's infused into a company needs to be proportionate to the ownership interest that they receive, and then profits need to be proportionate to that as well. Physicians or someone who's able to generate business, they have to be offered the investment on the same terms of anyone else. They can't be offered preferable terms. Lots and lots of factors, I could go on, but something that we always need to consider. Also, fee splitting requirements. These are state licensure requirements that sometimes prohibit percentage-based arrangements, for example, between management companies and new businesses. In corporate practice of medicine, these laws are in, I think, 20 or 30 states, not in Ohio, but definitely in New York and Michigan, and other states where I have a strong practice. Basically, the corporate practice of medicine provides that non-physicians can't own professional entities, and that any professional services need to be provided through professional entities. So what that means is that non-physicians can't invest directly in a healthcare provider unless they need to kind of go through a friendly physician model or a captive PC model, which we kind of set up on a daily basis, but it needs to be done carefully, or else somebody could be accused of practicing medicine without a license. So those are just some of the considerations. Just again, don't take on unnecessary legal risk. Physicians have worked too hard for their licenses to jeopardize them. They need some good guidance in this space. And that's it. I guess we'll kind of end the slides there. And if anyone has any questions.